So we should take a second and talk about the lawyering in this case. Obviously, there are trained attorneys prosecuting the case, or there will be, and there will be attorneys on the defense side. Dr. Hassan has employed a retired Army colonel as his civilian defense counsel. That's at his own expense. That person is called the civilian counsel or individual counsel. There will be detailed counsel who are uniformed lawyers made available by the government at no expense to Dr. Hassan. And he can also request individual military counsel, which would be an officer, one or more officers, requested by name, and they have to be made available if they are reasonably available. The interesting thing about this aspect of the military justice system is even if you were able to afford an attorney, and as a major, Dr. Hassan was presumably be in a position to pay an attorney, you get them for free under the military justice system. That's unlike the civilian justice system where only people who are paupers are entitled to, or indigent, are entitled to free defense counsel in criminal cases. The jurisprudence on this, by the way, is it's called the liberal grant rule, so that military judges are under an injunction, basically, to be generous in granting challenges for cause, so that if the defense or the government can come up with a plausible basis for releasing a potential court-martial member, the judge is supposed to grant it. Now, the process is not all that dissimilar from the civilian criminal justice process in that the doctrines relating to exclusion, for example, of racial minorities are applied, the so-called Batson issue, B-A-T-S-O-N. That's familiar territory in the military justice system. The military is alert. The military judges are alert to the potential for abuse in the exercise of challenges. And that's been a fruitful field, actually, for litigation. And I'm sure that that will have been thought through very carefully by all the players, prosecution, defense, and military judge. Incidentally, the prosecutor in a court-martial is called the trial counsel rather than prosecutor or district attorney. So if you see references to the trial counsel, that means the prosecutor.
Interestingly, along those lines, I think one thing you'd want to think about in an issue that might raise itself is the issue of religion. And I think that will be an issue when you think of the panel. I think you can expect to see some discussions. And that, unlike race and gender, which is a very clear grounds, in other words, the case that Gene referred to, Batson versus Kentucky, makes very clear that you can't strike somebody because of their gender or their race. Religion is not quite as clearly resolved, and I expect it to be an issue in this case in terms of, an issue of whether someone who is, either has strong Christian views or strong Muslim views, how they would they be an appropriate person to strike from the panel based on those views. The same is true issues of whether somebody is a firm believer or not believer in the death penalty. Those are all the type of questions that I think will be interesting to your questions that you kind of can expect to see and see perhaps some skirmishes.
So much attention to this case so far that you could almost already make up a shopping list of issues that might well wind up on the table if there is a trial. Evidence may be excluded by the military judge or admitted by the military judge. Those are areas that are fruitful sources of appellate litigation. Obviously, speedy trial is an issue. We've all heard about unlawful command influence, which comes up in a variety of different ways. Was the deck loaded? Were the dice loaded when the members were selected by the convening authority? Issues like that. We've mentioned venue questions. The insanity defense may come into play. Pretrial publicity, we've already talked about. Leakage of confidential information may turn out to be an issue. Wouldn't surprise me. Access to experts has been mentioned. The principle there is that there has to be equality of arms between the prosecution and the defense. And what you will probably see is requests for experts, both investigative assistants and technical advisors, such as physicians and psychotherapists and the like.
In this case, I would say that, and actually going back to the preliminary hearing, the Article 32 hearing, is not usually presided over by a judge. It's usually just, for lack of a better term, random, unaffiliated judge advocate. But in this case, I foresee a judge being assigned to the preliminary hearing and a very senior judge being assigned, if not the chief trial judge in the Army, being assigned as the trial judge. I can certainly foresee him detailing himself to this case because, again, if it's referred as a capital case, there aren't that many defense counsel or prosecutors who have the wherewithal and the experience to do those types of cases, and there aren't very many judges who would be mindful of all of the things that you all have asked about as far as appellate pitfalls. So I foresee it being a very senior judge, if not the senior trial judge in the Army.
Of whether or not, based on the evidence that's kind of found in the investigation, whether this case could be tried not just in a military court system, but in the alternative under kind of some terrorism-related charges. There were some early press reports of that. I don't think that's necessarily an issue, but those are the type of things that could certainly be looked at if the Attorney General or someone felt that these crimes were crimes of terrorism and therefore felt there was a different venue to try them, such as federal district court, much like we've seen with these other cases. That's kind of another potential point of conflict, I guess, between branches, or although that's all in the executive branch, but just the different types of issues that could surface in terms of how this case proceeds. There's kind of congressional issues, there's military versus civilian court issues that all kind of could become an issue.
8 years now. Some of these issues may intersect, and one of them is the willingness of the bar to come forward and represent individuals who are, let's say, deeply unpopular, or whose, the defense of whose conduct may be viewed with dismay by the American public. And I think it is a strength of our system that since the time John Adams defended the Redcoats who were involved in the Boston Massacre, members of the bar have been willing to come forward, civilians, but also uniformed judge advocates, to represent people who whose conduct, whose apparent conduct, let me hasten to say, is deeply baffling and disturbing to the American public. I think that's a strength of our legal.